And the 11th point is the 27 recovery, which becomes a link in the circumstance. Now, why, of course, there are threefold, as far as I could understand, subject to correction. There were threefold arguments on behalf of my learned senior friend. That one, the 27 recovery is not believable on three grounds: that the object was accessible to all, the lock and the key to the lock was with the relative of the accused. Second, he said that it's not distinctly related as it is required under section 27. And third, that there was no statement, recovery statement was not there. Taking these 3 points in view, I'll place the evidences to substantiate and to negate their arguments. Now, coming to the recovery part, first, it was PW10. Lordship will go to the statement of PW10, who along with the DSP, who was PW16, the SI, the cameraman, other police personnel.
Assisted by Mr. A. Barwa, counsel for the for the death reference case also present. The next date you also be prepared on that death reference. Yes, yes. Because the case citations, you just refer to those paragraphs, and then we take up the death reference.
Yes, I've given 2 judgment on death reference along with the paragraphs. Okay. What contains in the paragraphs also I've written in the written argument.
Try to complete within 10-15 minutes on the next date.
Lordship.
So we'll take up death reference.
Lordship. Yes.
Otherwise, we are next. We'll be facing that puja vacations. We don't want ourselves to be.
5th, we'll try to finish it along with the date reference. After
7 is 2017 matter.
but senior is not.
No, we have to wait for your turn. We'll look into the file and then only do something. We're not adjourning. Wait for the matter being called.
Right, please, your lordship. Lordship, with the consent of the other side, I beg to mention item number 11 of daily list. Kindly, matter may be adjourned for the day and listed after puja vacation.
Consent of the other side, the land counsel for the petitioner pays for adjournment. There is a law. List after ensuing puja vacation.
Daily list item number 1.
Suit has been filed by the plaintiff respondent for recovery of area rent from January 2006 onwards and eviction of the petitioner.
You are the plaintiff or the defendant?
I'm the defendant.
Okay. Both others on the other side of each other couldn't settle the matter. No chance of a amicable settlement.
Lordship, from 2006 Lordship, even after expiry of my husband, that the poor wife could not get the benefit of his own house, Lordship, without any rent even, Lordship.
Okay. Okay.
We are fighting, Lordship, from 2006 Lordship, for getting him evicted.
Okay.
Now,
yes,
they filed a title suit that has been decreed by the learned Munshi.
Yes.
Now, aggrieved by that, we filed an appeal for the civil judge. That was also dismissed, and therefore this CRP challenging both the decrees below.
But then you hardly have a chance if there is a concurrent finding. Yesterday, not yesterday, I think in 2 or 3 days back, the Supreme Court has deprecated reappreciation of evidence in a revision. Mobile assembly.
Here, Your Lordship, there was a deed of agreement, initial deed of agreement that was between the parties. That was on 1st December to December 2003. 1st December 2000 to December 2003. So that
agreement was not a registered agreement.
That was registered between both the parties. We have annexed it
Where is that?
as Annexure 1. Now, both the courts below did not take into
It's not a registered agreement. There's nothing here indicates a registered agreement. If it's not a registered agreement, we can't read in evidence. It's a tenancy of more than a year.
If it's not registered, then
There's a bar under 49.
yes, yes.
Because I'm because you see there are a lot of judgments. The Supreme Court saying that revision to be conscious about the power of the court under revision, where reappreciation of evidence has been deprecated. The recent judgment of 20 September 2023 of the Supreme Court by division bench. It limits the power of the court to exercise judicial power and reappreciate the evidence. You'll have to show us that there's a flaw in the legal appreciation of evidence.
Your Lordship, firstly, this unregistered agreement that was not considered, and second, Your Lordship, the salary from 2006, January 2006 till July 2007, we have deposited it before the court. First, we offered it to the respondents, then they refused it. Thereafter, we issued 2 checks in their name. They did not encash the amount. Thereafter, we are bound to deposit the amount before the court. Now we have deposited it before the court, and also challans has also been issued. The exhibits were exhibit 01 to 029.
You have produced a bank account
Yes.
as evidence, which is what is that? Exhibit number.
Exhibit number 01 to 29. Those are the
No, your bank statement. Have you produced a bank statement as evidence? Have you proved the bank statement in evidence?
I have the challenge with me.
No, no. You see, I'm asking you for a particular reason. You say that you deposited two checks, gave two checks to the landlord,
Yes.
which she did not encash.
Yes.
Correct. That is your stand.
Yes.
That means previously also you would have been paying by check.
No, previously we were paying by.
So therefore, you see, it's a
see,
this document of check is within your custody. Whether you have issued and paid it to her, that can't be an evidence. If you have a practice of giving by check, and then she refused to, then she failed to deposit one, would be an evidence in your favor. But if you are paying by cash, out of a sudden, why will you pay by check?
because initially we said them that to accept that cash amount, they refused that. They said that on subsequent renewal of the agreement.
So therefore, you see, if you will vary the check, the refusal is certain. That is not a regular, what we call a step taken in usual course of ordinary business. And then in your evidence, it has come out somewhere that check for 2 months was not encashed, and therefore you approached the court and deposited money by challan. So therefore, it's a 2-month deposit made.
Yes, 2 month. We
So-
deposited on.
So
There
there
are
was-
2 check numbers also.
No, it's okay. But there are 2 deposit made, made in one challan. It shows that the payment was not made within a fortnight of its falling due.
Yes.
So then otherwise also you fail. If you can show us that the deposit was within the meaning of section 5(4), then you have a what you call have an arguable case. But if that fails, and if a challan itself shows that there are 2-month deposit in a same challan, then 5(4) is not complied with.
That it was not made within a fortnight. That is.
Then we can't reappreciate evidence.
Then your lordship, that agreement at least that should have been considered by the courts. That initial agreement. That has also come out in that evidence also.
No,
They have
because that, you
accepted it.
see, it may have been exhibited,
Yes.
but for this court to go into to appreciate that, you'll have to show us that how we can overcome the bar of section 49. It
Then your
starts with a
lordship,
non-obstante clause.
the evidence can be gone into the evidence of the PWs.
Shows
the
that.
cross-examination.
Shows that.
I'll first read the cross-examination of PW1.
Just let me get the LCR. Yes.
It starts with the suit land and
Yes, the suit and premise was owned by Padmanath Tai.
and Prasanna Tai.
Hmm.
Ramlal Tai is my father-in-law. It is not a fact that Ramlal Tai was the original owner of the suit land and premise. The defendant came into occupation of the suit premise firstly in 2000. I did not mention about the same in the pleadings. It is not a fact that I suppress the fact that the defendant came firstly in 2000 as a tenant. It is not a fact that the statement to the effect that after purchasing the land in 1974 we constructed house premise therein is false. There are total 6 shop premises constructed in 2000. In 1999, the earlier premises standing thereon were gutted by fire. The earlier premises were constructed in 1974. There were 8 premises in total. The earlier tenant, Sri Pranas Jyoti Lavkar, is still in occupation of the premise on rent. It is not a fact that the tenants were evicted by me forcefully. The other tenants were about 20 were for about 25 years. We took rupees 85,000 from the defendant as security money, and which is now under my custody. Now, this clearly shows that one advance sum was taken of rupees 25 of 80 amounting to rupees 85,000. Now, this amount they could have adjusted for the rent from 2006 to 2007. Now, it is not a fact that the defendant constructed the suit premise by spending rupees 1,50,000. The elder brother of the defendant's husband, Bura Gohai, is a tenant under me in 2 shop premises with a rent of 3,000 per month. It is not a fact that Dilip Bura Gohai constructed those 2 rooms. It is not a fact that the other tenants also constructed their respective rooms by spending their own money. On 1/12/2000, the defendant executed a lease agreement with the plaintiff. It is not a fact that the statement relating to construction of room measuring 9 feet into 16 feet with so and so, as written in clause 2 of the agreement. The statement made in para 2 of that agreement occurred due to printing mistake. This was detected by me while I consulted with my husband. I cannot say whether the original copy of the agreement of 2000 is with me. If my advocate received the notice to produce document, I cannot say. It is not a fact that Exhibit 21 was prepared without giving opportunity to the defendant to go through it. He provided no copy of the agreement of 2005 to the defendant, since she did not turn up to collect the same. As per clause 7 of the agreement, 3 months notice is required. While Exhibit 18, we issued legal notice giving only 30 days. I know that defendant not only have pharmacy license, but I do not know whether he is having trade license or not. I cannot say whether it is mentioned in the agreement that the defendant is required to take permission if she wants to change the business. I know that the defendant did not pay the electricity bills from 2000 to June 2008. The electricity connection was cut off in 2007 and recently it has been restored. The defendant paid all the expenditures for electricity connection. Exhibit A1 to A50 are the electricity bills paid by me. In 2007, the defendant installed a signboard so and so guessing, on which I stated that she sublet the premise to some other person. It is not a fact that the suit premise is not required bona fide. It is not a fact that in March 2007, the defendant, her husband and advocate Gautam Borua tendered rents to me, but we did not receive the same. We shall return the security money if the defendant vacates the payments. I do not know if the defendant is depositing the rents in the court. It is not a fact that the husband of the defendant on 6/5 and on 7/6 tendered rents by way of check. We did not receive any notice if the defendant issued on 12/5/06. It is not a fact that in order to evict the defendant forcefully and to misappropriate the money, we have filed this case. It is not a fact that we are not entitled to get any relief as paid for. This rent amount that could have been adjusted from that 85,000, which we have deposited as per the previous rent agreement. And secondly, your lordship will see that as per that agreement, 3 months notice period ought to have been given. 1 month notice period was given. That was also illegal. So this cross-examination part that can be taken into account.
Mr. Dutta, you have to address us under the scheme of the Assam Urban Area Rent Control Act. There you see what has happened is, under the Urban Area Rent Control Act, if you default, you are entitled to be evicted. Question of notice is not envisaged there. It is otherwise determination of agreement when you get 3 months notice. This is not an ordinary determination of tenancy.
There is one deviation of the apex code also here. (1987) 4 SCC 546.
1987.
4 SCC 546.
Paragraph
Paragraph 2 will be the relevant.
2.
Yes. MS Sarvan Kumar Omkar Nath versus Subhash Kumar Agarwala. May I read the second paragraph? In this particular case also, the tenant failed to provide 2 months rent. So that was adjusted from the advance which we paid to the landlord.
You know the reason. It's there in the judgment in para 1, but I'm still showing it to you.
That judgment has been overruled, Lordship, in subsequent judgment of the Supreme Court. Lordship. I'll place that.
It's okay, but this is not a this Supreme Court judgment will not be applicable in our state.
Yes.
The reasons I am telling it to you.
Because perhaps with the Bihar Tenancy Act was
Yes,
passed.
You see this section 3
Section-
of Bihar Building and Tenancy Act.
It shall not.
What
be,
does it say?
It shall not be lawful for
Huh.
any person to claim or receive, in consideration of the grant, renewal, or continuance of a tenancy of any building, the payment of any premiums, salami, fine, or any other like sum in addition to the rent, or the payment of any sum exceeding 1 month's rent.
Correct.
That means this.
So therefore, you
accepting
see a demand of 2 months rent was contrary to section 3,
of- Yes, yes.
and therefore the Supreme Court says that it couldn't be done. And that's not a good what you call that would not be that ratio would not be applicable in Assam, where you have the default under 5.4. So para 2 need not be gone into. Even if Mr. Datta says it has been overruled, we will not even go by that. The on facts and the law in which the issue was decided are totally different. So therefore, you see the question of adjustment or the 2 months rent not being adjusted, that could have been a valid ground under Bihar.
Bihar Building Lease and Rent.
Huh. You find it in various acts in the country, same provision. So therefore, it was just a just thought that this same thing would be here, and therefore I searched.
Your Lordship,
This will you'll find in para 1, page 2. If you turn your page 2, about 6-7 lines from the above, 10 lines. And that under section 3 of the act, it was not lawful for a lender to claim or receive in consideration of grant renewal or so and so any Islamic finance so and so. And therefore, 11 eviction process under 11A was deprecated.
Otherwise, I don't have a case, Your Lordship.
You are there in the Supreme since 2000.
Yes.
We give you 6 months to vacate.
1 year,
No, 1 year will be too much.
probably nine months.
Lordship,
No,
my client is a
Thir-
cancer patient, Lordship, counting his last days. This is the pathetic condition. My client is a lady, Lordship, after losing his husband with 2 unemployed youth, Lordship, he is surviving with his cancer in his ailment, which is his body, Lordship.
Okay. So
Otherwise,
30
6 months, I am
30
benevolent to my
31st March to vacate that.
Lordship.
Heard. Besides the third on the counsel for the petitioner and Mr. P. Dattar on it. Counsel for the respondent. Next paragraph. By filing this revision under section 115 CPC, comma, the 115 read with article 227 CPC, comma, the petitioner has assailed the impugned judgment and appellate judgment and decree dated 5/11/2013 passed by the learned civil judge Dibrugarh in title appeal number 40 of 2011, by which the judgment and decree dated 21/6/2011 passed by the learned Musif number 1, Dibrugarh in title suit number 74 of 2007 was affirmed. As a consequence, as a consequence of both the of the concurrent finding of both the learned courts below, comma, the petitioner is facing imminent eviction from the suit premises described in the schedule of the plaint, as well as described as well as in the decree. Next paragraph. In brief, comma, the case of the petitioner, the case of the respondent plaintiff in the suit is that she's the owner of a plot of land measuring 16 superscript 5 oblique 114 Lessa land covered by dark number 294 within bracket new of periodic patta number 146 of village East Chowgitingi, CHOWKIDINGI, within Dibrugarh town, within Dibrugarh town Moza, and located at Lachit Nagar, Dibrugarh, along with houses standing thereon, which are covered by municipal holding number 112 and 113. Full stop. One of the rooms constructed by the respondent was let out to the petitioner / tenant by virtue of an agreement dated 1/1/2005, during the currency of the tenancy, the suit premises was mutually divided with the other co-owner, and that the suit premises which is between the co-owners and the properties falling under holding number 112 fell in the share of Pradeep Nath Taye, Padmanath, PADMA, Padmanath Taye, predecessor in interest of the respondent numbers 1 and 2, 1, 2, and 3, and the properties covered by holding number 113 fell in the share of Prasanna Kumar, PRASANNA, Kumar Taye, TAYE, respondent number 4. The agreement, the agreement which had lapsed on 1/12/2006 was not extended, and then the respondents claim that the respondents allege that the petitioner had not paid monthly rent for the suit premises since January 2006 and was a defaulter, and therefore a legal notice, a lawyer's notice dated 12/4/2006 was issued, and thereafter the suit for eviction was filed. Amongst others, for eviction of the petitioner from the suit premises. So file A2. PS of file A. Interesting. File A now. File A. It is up. for eviction of the respondent, her men, dependents, etc., and for recovery of caste position, permanent injunction, cost, etc. The petitioner contested the said suit by filing a written statement denying the allegations and stating therein that an advance of rupees 85,000 was paid to the respondents and that the suit premises was constructed by her by spending a sum of rupees 1,50,000, and that the other tenants had also made their own construction. First, it was also pleaded that the suit premises were taken on lease by way of an agreement on 1/10/2000 at a monthly rent of rupees 1,000 per month, which was subsequently raised to rupees 1,150 per month from January 2005. To stop. The stand of the petitioner was that the advocate's notice was suitably responded to. It was also stated that the petitioner had offered rent to the respondents, which they refused to receive, and therefore on 6/5/2006, the petitioner had sent rent to the respondents by way of a check for a sum of rupees 4,600 towards rent for the month of February, March, April, and May 2006, and that on 7/6/2006, another check for rupees 1,150 was sent to the respondents for the month of June 2006, which were not presented. First off, in the written statement, description of 8 missed NG cases regarding deposit of rent from the month of February 2006 to July 2007 was provided. First off, it was also stated that the it was denied that the petitioner had negotiated with some other persons to sublet the suit premises, and accordingly, prayer was made to dismiss the suit. First off. Next paragraph. The learned trial court, on the basis of pleadings, formatted the following issues for trial. Frame the following issues for trial. Page 29. Red pencil mark. 29 and 30. Huh? Stop. Next paragraph. The respondents of the plaintiff side examined. You examined 4 witnesses.
Lordship.
4 witnesses, and had exhibited the following documents.
Plaintiff 3 PWs. Lordship.
3 PWs and exhibit the following documents. Mr. Gata, you just note down the exhibit numbers and give it to us.
Lordship.
So and so document within bracket exhibit A. Just give that, it will be incorporated in the order. And you also, your defendant evidence, please note it and give it to the court master. But then I won't spend time on that. You examined how many witnesses? 2 witnesses.
2 witnesses.
And the petitioner or the defendant had examined 2 witnesses, so and so, and had exhibited the following documents. Full stop. That's it for the 29, 30 question. That will be page 19. Next one. The done trial court on examination of the materials available on record. Come on, held in respect of issue number 1. That the suit was maintainable on facts and law. So in respect of issue number 2, it was held that as the respondents alleged that the petitioner was a defaulter, which was denied by the petitioner, there was a further action. In respect of issue number 3, it was held that there was no evidence to show that any construction over the suit premises was made by the petitioner. And there was no condition for adjustment of rent as per the terms of the rent agreement within bracket exhibit 21. And therefore the issue was decided in favor of the respondents. In respect of issue number 4, the Learned Trial Court, the note of the contents of exhibit 18. The advocate's notice, wherein the respondents had asked the petitioner to vacate the suit premises and to pay area rent from January 2006. Full stop. Referring to the evidence, it was held by the learned trial court that the petitioner was a defaulter in payment of rent from the month of February 2006 and further held that the proceedings of Ms. J case number 77 of 2009 within bracket exhibit F within bracket 25 was dismissed for not depositing challan and also to note of the contents of exhibit T within bracket 1 that the petitioner had deposited rent from February 2006 till December 2006 by one challan. That is by one challan. T1 is one challan.
T1 is one.
One challan. And it was held that the rent was not offered within the first week of each succeeding month. And it was also held that the rent deposit cases by exhibit T within bracket 34, T13 within bracket 39, T within bracket 36, and T within bracket 24, the serial killer had been dismissed for not taking steps. And accordingly, it was held that the requirement of section 5 within bracket 4 of the Assam Urban Area Rent Control Act was not fulfilled. And accordingly, the issue of defaulter was decided against the petitioner. Continue at 2.
Item number 12 it is wrongly listed in hearing column as there was an order on, for only that, Lordship. So, Lordship, this matter may come for orders. It's a review matter.
At 2 o'clock, it's
Lordship.
a review matter. That's a review matter.
matter,
I will
Lordship.
just see why it is there.
Lordship,
Since a review matter, we have
Lordship, there is an order passed by Honorable Justice Vijay Shekhar. This matter will come after 2 weeks for hearing. So it is listed in the hearing column. In fact,
just
Lordship,
let me go through the records. At 2
Lordship.
o'clock, I'll if we'll not take it up, because I have not seen that record.
Lordship,
The views of this bench,
no, Lordship.
then
Honorable Justice H.K. Sharma, Lordship. Hitesh Sharma, sir. H.K. Sharma.
also it will come before any other any
Civil
bench.
bench one,
Okay,
Lordship.
civil bench one matter. Okay.
Lordship.
Let me go through it for once.
এদের কি বলে এগুলো বলতে কি হয় এস এটা এস নো ও এস ওয়ান না 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 ওটা নিবেন এমনি সারে চলে যাবে না নেবেন ও দাদা কিন্তু দিব দে নাম্বারটা number to the option.
কি কৈছা?
Number to the option.
মোৰ
হা?
মোৰ নাম্বাৰ মানে মোৰ ফোন নম্বৰ লাগিব।
Uh,
মই একচেপ্ট ফোন নম্বৰ I don't have any other number. 945
4351
4047
404. Oh, আছে তো। Expect পঙ্কজ বুলি। ফটো ইউজ আপোনাৰ চক।
ডাঙৰ
এইটো চক। দেউতাৰ চুট কৰা আছে।
মই আজি পঠাই দিম আপোনাক হা বস্তুটো মই লাগিলে মই কি মই বুজি পাইছো ময়ো এদিন এপ্লিকেশ্যন আহিছে তেওঁৰ লগত লাগি আছো ঠিক আছে পাৰিছো
QRST এটা টি আহিব আৰু অৰ্ডাৰটো চেক কৰিব T2 কি হয় total का सीट किमान है एक किमान আছে জানে total exhibit T2 মানৰ পৰা লৈ কেনে কিমান আছে লাষ্ট জানে
419 লৈকে আছে জানো
না না সেটা তো ও सर्विस करो इसको लिखा है नहीं एविडेंस थी वो तो ठीक है वन नोट मेरे खेलियो पर Iboni. Khobor lek. Man's not. Wait. Wait. Nine. Oh, itu sih itu ya. Nine. Oh, itu. T1 to 42 seconds. না T1 ও আছে এটা জাজমেন্টত দিখা আছে এইটো ওপৰত আৰু তো নাই এটাৰ পিছত একো 2010 9 9 NJ cases. Insurance policy of shop hobo যেন পাইছো সব লিখি থৈ দিও দেখুন কি বলছিস কি কোশ্চেন এটা item number 1 CRP gimana semua Did you
তোমাক কি লাগে
মোৰ এই T2 D1 to 42 হ'ব লাগে স্যার লাস্ট মানে DW evidence মানে exhibits T2 এর লাস্ট নাকি PQRST T লাস্ট তো সাথে 42 নাকি হয় না মানে এক্সট্রা কে এটা দিয়ে আছে কত
বেলেগে ফেল কৰিব পাৰে DW2 বা 3 ফেল কৰিব
হ'ব তেনেকৈ দি দিম এই এটা পাইছো মই 42 লৈকে আছে দাদা বহক
sir. Sorry, sir. Code. वो भी कोड के अंदर है हाँ ओके ओके सर मैं दीपांक को सर वो कोड भी तो आपको बता रहा हूँ सर ठीक है सर
হেৰি এই আপুনি তালে গৈ তেওঁলোকৰ লগতে সম্পৰ্কৰ লগত কথা হৈছে আৰু আমাৰ দুজনকে ইয়াত লৈ ছাৰ নাথাকে ভিতৰলৈ যাওকচোন হা এই শৰণৰ লগত মই টয়লেটত গৈছোঁ
तो पार्टी सेटेशन में चाहिए अपन को আমার সমনা বুদ্ধ কো দাম পাবো এই 2000 টাকা দেখো বুঝে দাও
ছাৰ আৰু আমি দুজনে মিলি এই শৰণালৰ বিদায় আমি একেলগে দুজন গৈ পালে আমাৰ আকৌ শৰণা ছাৰ এতিয়া পকাই দিলে খবৰ ল'ব আমি বেলেগে বেলেগে কাম ছাৰ আহিলে
মই যাব লগা আছে কিন্তু আধা ঘন্টাত গৈ আহি নাপামহি একেবাৰে 2টা বজাত এইটো ল'বই দিওঁ দেৰিকে বহিব নবহে না
নবহে ছাৰ চাইকেল লগাই যাব আৰু আর মিষ্টি দাম করে মাত্র কি আহার থাকবো অসুবিধা করে না তাদের কিছু করার খবর থেকে ঠিক আছে আজ তারা তুমি এইমাত্র বলছো পড়াশোনা করো তাহলে এদিকে এটা আজকে দুদিন আজকে দুদিন না কত দিন আমরা
Hello. Hello, Shivapala. Okay, guys. Actually, near to where the
First road is.
किया था किया था लेकिन नहीं दिया ना वो एक क्या है वो अरे वो प्रपोजल लिस्ट क्या उसका बात वाला नहीं होगा क्योंकि सेट में ये दो नंबर नहीं है उसका बात
Agreement.
T1, T1. It was T1 as per the judgment. From February 2006. December. Your Lordship may look at page 24 of the judgment. There it has been stated by exhibit T1. She deposited the rent from February. T42 লোকে আছে আমি চেক করেছি 42 লোকে আছে পুরা 2010 লোকে
Lordship. Oh no, Lordship, that respond number Lordship. I'm the solo. One Lordship, the limit I.
The enhancement. No, it was 1150 as per the, yes. 2005. Yes. Only the period that may be extended to April for vacation.
Obliged.
Obliged.
As a lawyer, he is successful. In rent control, in this type of suit Lordship, being a lawyer, he is successful from 2016 today. He has given enough benefit to his client. Because 2006 to 2023 lordship, he has given enough benefit to his client. Obliged, lordship.
Obliged.
Item number 2. For hearing.
But in item number 3, but I am on behalf of the respondent. The learning council for the petition already expired. Expired. So, my lord, in this case, my lord, this is no merit, my lord. Actually,
premises of the appellant is situated at SRCB Road, Pennsylvania, Guwahati 781001. This is not disclosed in the claim petition in this memo of the according to the notice will be sent in the correct address. This one. The registry shall submit a postal track report as well as a note of service on the next date fixed. Next paragraph. The petition, the appellant is put to notice that on failure to appear before the court on service of notice, the court shall presume that the appellant is not interested to pursue the matter and the same and adverse orders will follow. Notice is made returnable on sense.
1611.
Accordingly.
Or
May it please your lordship. Lordship, similar matter was heard, my lord, by the Honorable Justice Parthiv Jyoti Saikia, my lord, on 21st September 2023, and the judgment is reserved for orders, my lord. So, my lordship, if lordship permit.
Join matter.
yes, same matter, my lord.
Same matter.
So, my lord, lordship in other cases, so lordship passed number of judgment number of cases, my lord. This is the shortage of this consignment loaded with the remote under the section 65 with remote said to contain. So, rail is not liable. Lordship also passed number of cases, same order, my lord. So, I am burden of proof lies on the consignment. What is the quantity of volume or weight of the consignment?
I don't remember. I won't remember. It's a long
I
time.
already submitted your judge lordship judgment. Also. In MFA 272/2010, the lordship judgment, and another is a common judgment, MFA 92 of 2016. This is a common judgment passed by this honorable court in number of cases. Further, I have submitted some judgment of the Nagpur High Court, Odisha High Court. The burden to prove their loss occurred there is on heavy on the plaintiff, the consignor, and shortage certificate issued by the railway is not enabled. The shortage certificate, this is consignment was loaded from the private siding and is unloaded at the private siding also. It is protected by section 94, 97 of the railway Act. So moreover, my lord, there is no proof of actual delivery of the goods to the care of the railway for dispatch, because it was loaded by the consignor at private siding and it was not supervised by the railway staff. So railway is not, they already accepted the weight or volume of the consignment as per made by this consignor, and which was reflected in the railway receipt for the collection.
No, just a moment. You are ready for hearing?
Lordship, my prayer is, since the matter is reserved for orders, my lord.
No, if you see, if the court has already decided such matters.
Lordship, there are
irrespective of-
numbers of judgment
No, no.
which goes in my favor also, my lord. So there are difference of opinion, my lord.
No, when you read before the appropriate bench, I can't say, because if judgment which is authored by this bench is produced before this same bench,
Yes,
I'll be going by this. So if there is another opinion, it is for not this bench to see. You have your remedies elsewhere.
what is this similar matter cases covered by this judgment of
No,
this
no,
order?
if both are ready for hearing, then we'll take up the hearing. Otherwise, the other opinion which is expressed by another bench is after 21/3/18 or before that?
No, my lord.
No. Just Ms. Sharma say.
My lord.
The different opinion expressed by this by another bench of this court was of which date?
Lordship, after 21/3/2018.
21/3. So that would be then law is well settled.
Lordship, this,
The other bench would normally, if this judgment is shown to the bench, a single bench cannot give a contrary judgment. Therefore, either it is in without knowledge of this previous order, it will not be binding on this bench then. Subsequent opinion expressed by the court without taking into notice the 21/3 would not be binding on this bench.
But there is another judgment 21/5/2020. The same judgment has been passed.
21.
5/2020 in MFA number of MFA. MFA number 92 of 2016. My serial number 2. Already I flagged my list. 2. MFA number 89 of 2016. MFA 70 of 2016. 106 of 2016. MFA 88 of 2016. 71 of 2016. All the same. The judgment has been passed, my lord. Is it remanded back to the railway claim tribunal for further test decisions?
You show me the judgment where the contrary opinion is expressed.
Lordship, today I have not carried with myself, my lord. I
But you
need
see
some
this-
time, my lord.
No, Ms. Sharma, this 2013 matter. You're not adjourning at that drop of a hat. If you're
Then
not
Lordship
prepared, you have
will
to
hear
bill for
this
it.
matter on merit, my lord.
Then go for the hearing. 2013 matter, I'm not adjourning like that. Yes.
Here the concernment, this appeal is filed by this railway under section 23 of the Railway Claim Tribunal Act against the judgment dated 27/6/2014 passed in OA number 1362 of 2007, wherein the Railway Claim Tribunal directed to make payment of the awarded amount of rupees 8,71,223. The annexer 1, my lord. So in this case, actually main brief fact of the case is that the consignment was loaded from Rajban, this is Durgapur subdivision, the West Bengal, district Pachim Bardhaman, from Rajband to Tinshukia. The consignment of the kerosene oil was loaded at a private siding of Durgapur, Rajband, by the consignor, and they already they fill up this forwarding note, and as per section 64 of the Railway Act, and where they have mentioned how much they have loaded this consignment. And
But Ms.
according to
Sharma, you see, except for the item in this case it is kerosene oil. The legal point involved in all the cases are same.
Same.
So why you are compelling us to do the hearing? You see,
Because-
what will I do if one quantity is supposing in the first case it was rice, in the second case it was
Yes.
sugar, in the third case is kerosene. So you think that we have so much of liberty, so much of leisure time that we will
Lordship,
spend on hearing it afresh,
because,
except
my
for the
lord,
change of goods.
in the present case, my lord, the consignment which we are dealing, my lord, that is SKO, my lord.
Yes,
kerosene oil.
kerosene.
Yes,
That's what
my
I am
lord.
saying. Kerosene.
And my lord, in case of oil consignment, my lord, there is a circular issued by the railway board, my lord. When the consignment book from the siding, my lord, the railway has to issue clear RR, clear railway receipt, not said to contain RR. I have that, my lord, circular with me, my lord, which your lordship kindly see that. So said to contain plea is not available with them, my lord.
But this is not a factor which was taken into consideration by
And the said
by the,
observation was made in the judgment itself, my lord,
where is
passed by
that?
the Railway Claims Tribunal, my lord.
Where is that?
In
Only
the,
refers to 1512 and 1513,
in the judgment, my lord, page 4,
page 4.
issue number 2 and 3, my lord, page 4, last paragraph, my lord. Fifth row from bottom, my lord. Fifth row from bottom, my lord. The applicant has filed circular dated 25/1/1973, my lord.
Show me that circular. Yes. So did you lead proof in the before the RCT that you had made payment of the for the requisite number of commercial staff for supervising loading of wagons? Did you?
My lord, that question was raised, my lord, and the respondent counsel cannot say that they have, my lord, this observation is there, my lord, at page 5, my lord.
Page 5.
Yes, my lord. Admittedly, my lord, it starts from admittedly, in the present case, there is no averment made by the respondent that on account of non-cooperation by the applicant company, no clear railway receipt was issued, and that the staff working at the forwarding station was compelled to issue a railway receipt with a remark said to continue. My lord. As per this circular, my lord, 1973 circular, which is still in force, my lord, till 2018, my lord, clear railway receipt should be at least issued from the sidings, my lord, owned by the customer, my lord. Further, my lord, the burden of proof shall lie upon the consignor in terms of proviso to section 65, my lord. That burden is also, my lord, discharged by the party, my lord, by the respondent. My lord, in the railway receipt, my lord.
Lordship, my client have a look at page 5 of the judgment, my lord, running page 5 of the judgment.
Let Mr. Sharma complete her part. Let Mr. Sharma complete her part. Yes.
Second point is, my lord, as per section 65, the proviso says that, my lord, if in the case of a consignment, whether in wagon load or train load, and the weight or number of package is not checked by the railway staff, my lord, and a statement to that effect is not recorded in the railway receipt, my lord, then the burden of proving the weight shall lie upon the consignor, and endorsee, my lord. In this case, my lord, the railway receipt, my lord, in the railway receipt, there is a column, my lord, where deep measurement was taken, my lord, by the IOC at Rajband, my lord. Rajband is the booking station, and the stamp and signature of the siding, my lord, Rajband, is also endorsed in the railway receipt. Deep measurement was taken in each wagons, my lord, and it is, my lord, manually handwritten, my lord. The entire railway receipt is computerized, my lord, but that column was manually, my lord, entered, my lord. 261.1.
Deep measurement.
Yes, my lord. And it was endorsed by Rajband IOC siding railway, my lord. The signature of the concerned person and the stamp is there, my lord. Second thing, my lord, the remark, qualified remark, my lord, at the bottom of the receipt, my lord. There is a mention that load condition fulfilled, my lord.
Where?
My lord, qualified remark, just below, my lord. Qualified remark, wagon selected by sender, wagon examined by TXR, declare fit and watertight, deep measurement, measurement not witnessed by railway staff, sender's weight accepted, said to contain, packing condition, outer not compliant, load condition fulfilled, my lord. Here, in one hand, they are saying that, my lord, the consignment was booked under said to contain, and now they are saying that loading condition fulfilled, my lord. It's contradictory, my lords, this remark. So this qualified remark, my lord, cannot be relied upon while deciding the case, my lord, while deciding the claim of the applicant, my lord. In this case, deep measurement was taken, which was manually handwritten, my lord, by the IOC siding Rajband. And here, as per the short certificate, my lord, they also admit that out of 48 wagons, my lord, 38 wagons found without seal of top and bottom, my lord. So it suggested, my lord, criminal interference, my lord, en route. So the wagons were, my lord, criminally interfered. And in the notice, my lord, we have also stated that the wagons were arrived without seal condition, my lord. The sealing condition was there, my lord, in the notice. The lordship have observed in one of the judgment in MFA 216, lordship, this judgment passed by your lordship. In that judgment, my lord, the consignor, the applicant, my lord, lodge a notice under section 106, my lord, where he have not mentioned about the preservation of documents, my lord. So in this case, my lord, we have rightly intimated to the administration of the railways, my lord, regarding sealing condition, and which is rightly mentioned in our notice, my lord. So my lord may kindly see the notice which we have filed with our claim application. Notice dated, my lord, 29/5/2007. 23/5/2007.
Your claim petition.
Petition, my lord, page 6 to 25, my lord. It's a prescribed format, my lord.
It's a letter written by the Indian Oil Corporation.
Yes, my lord.
2012-2007.
23/5/2007, my lord.
Yes.
23/5/2007. Lordship may kindly come to serial number 22. Remarks, if any.
Yes.
My lord. B. Sealing condition. All tank wagon beers top and bottom seal missing, my lord. And accordingly, my lord, missing goods damage report was, my lord, issued. Missing and damaged goods report, which may lordship can see from annexure, my lord, sort certificate. Along with sort of certificate, there is one more report, missing and damaged goods report. It is at page, my lord.
Missing and damaged goods report.
Yes, my lord.
Yes.
In this document, my lord, here the condition of the wagons is mentioned under serial number 5, my lord. Were unloaded at goods shed or private siding. If booked to private siding, the condition of seals or packing at the time of making over at the point of interchange. Unloaded at IOCL siding, Tinsukia siding, out of 38 wagons found without top and bottom seal. So this missing and damaged goods report was issued by the concerned section, my lord, by the SMSSCM. This is some official of the railways, my lord. This report was issued just after arrival of the train, my lord. This missing goods damage report.
Yes.
So, my lord, this absence of seals, my lord, top and bottom seals, clearly suggests that, my lord, there is a criminal interference, my lord, en route, my lord, and they could not produce the documents that, my lord, necessary in terms of rule ISM rule 1714, my lord, which we have also rightly informed to the railway administration through our notice, my lord, regarding the sealing condition of the tank wagons, my lord. So they, my lord, unable to produce that documents before the London Railway Claims Tribunal. And so far as the burden of proving of weight is concerned, my lord, that we have rightly mentioned in the railway receipt regarding, my lord, the deep measurement, which was taken by the IOCL staff, my lord. And written, it was mentioned, my lord, and this aspect was not, my lord, disputed at the time of, my lord, hearing, my lord, and neither they have refuted in the written statement, my lord. So as this is my humble submission, my lord. In this regard, I have also like to produce one judgment of the Honorable High Court, my lord, High Court of Delhi, my lord. This judgment was passed in the case of Union of India versus Indian Oil Corporation, my lord. This lordship can produce this judgment.
Yes, Mrs. Chakravarti, what do you have to say?
Yes, my lord. My lord. So for written statement is concerned, railway is contested matter before the RCT by filing written statement. While they have already pleaded that the consignment book at the forwarding station with the remarks the railway receipt said to contain, and wagons selected by the senders. Wagon is filled out by the sender in the private siding of the IOC. So the wagons were examined by this TXR, declared fit and watertight. It is correct, future written. But my lord, in RR, it has mentioned that clearly the RR clearly reflects that valves were defective at the time of entrustment and alleged shortage were due to defective packing.
They're reading from where? If you read that, I'll not understand. They're reading from where?
Lord, you kindly see my grounds, my lord, at page 5 of my memo appeal. Ground 2 at page 4. For the land, page 4, ground number 2.
Yes.
For the Learned Tribunal ought to have taken a note of the fact that appellant railway as respondent while filed written statement categorically admitted the booking of the consignment and denied the value of the consignment. Moreover, the consignment in question was booked and loaded without supervision of railway staff at forwarding station as evident from the remark of the original railway receipt, which is recorded as a said to contain. Wagon selected by the sender, wagon examined by TXR declared fit and watertight, deep measurement not not witnessed by the railway staff. Sender's weight accepted. Packing condition outer not compliant. Load condition fulfilled. Loading is complete. Seal was done by the consignor. Everything is done by the consignor. Railway has not supervised. No railway staff is there. So far, notification dated 25/1 of 1973 is concerned as alleged by the respondent. I have already mentioned in my ground number 5, 11 page 5. Ground number 5. For that, the learned tribunal was wrongly held that the railway has failed to comply with the instruction of the circular dated 25/1/1973 issued by the railway board. However, the fact remains true that the latter part of the circular which says that and whenever the existing strength is not adequate, clear railway receipt should be given at least in respect of those wagons which can be supervised by the present staff. As per railway circular, it is mentioned that when the railway staff will supervise this loading, then they will issue the clear railway receipt. In this case, railway staff has not supervised this loading, so question of clear issue of the clear railway receipt does not arise. So, it appears that there is exception to the rule of issue of the clear RR. The same is not mandatory, rather subject to availability of the railway staffs. As such, the finding of the tribunal is perverse and not sustainably law.
You read the clause in this railway receipt. What do you mean by that language? Railway receipt.
Railway receipt is, my lord,
Read
under
that
section
language.
65.
No. Read the language used in that railway receipt. That packaging outer not compliant. That part, please read from the document.
Qualified remark.
Sender superior kerosene oil. Remark. Wagon selected by the sender. Wagon examined by the TXR declared fit and watertight and measurement not witnessed by railway staff. Sender's weight accepted. Said to contain. Packing condition.
No.
outer
Don't miss
not
the
com-
word. There's a word okay. Okay packaging condition, outer not compliant. What do you mean by that?
Okay.
Now, what do you mean by that?
Okay, packing condition outer not compliant.
What do you mean by that language? What do you mean by that language? There is no comma, there is no full stop. The words are okay packaging condition outer not compliant. Please tell us what does it mean?
Yes, okay, packing condition outer not compliant.
That is your document. I just want to understand it.
Even me also, I also don't understand what is this.
If you don't understand, you fail.
Because the outer packing condition outer not compliant.
If it is okay packaging condition, outer not compliant, outer means what?
Compliant.
Outer of what?
Outer not compliant.
It is just like Amazon sending us some goods. There's a carton outside which is not compliant, but its seals are there. In your case, the seals are missing.
No, seal is missing. It came later on. Seal was done by the senders.
I understand.
I did not put my seal.
So seal also you don't supervise.
No, I will not, but because already wagon is handed over to them and they will load the consignment at the private siding, and only for carriage they are issuing the railway receipt. Only for the carriage. not for anything. Everything is done by the senders. So the outer packing also would not supervised. But in RR,
So
in RR also,
your staff do not do anything. They get salary, I think.
my lord,
They get salary for coming and going. Your railway staff in the siding,
no, he is not going siding. He is in office. When the concerned will come to him after filling the forwarding note, that as per the forwarding note, whatever the concern value or the volume or weight of the concern is written in forwarding note by the senders, consigner, railway only accepted this thing. And
Sharma,
then
how
they're
do-
writing in the on the
what
railway
is the
receipt.
proof of sealing? What is the proof of sealing?
My lord.
How do you show the proof of sealing? You said that you was sealed.
Seal was made by done by them consigner.
What is the proof of seal?
Lordship. At present, my lord, I cannot say, my lord, because
take
there
this.
is an ISM rule, my lord. There is a ISM rule, my lord. So the seal condition, like,
No. There must be something on record to show that seal condition. See this record. Take up
There,
after some
there.
time. Just go through the record in the meanwhile.
But the respondent, my lord, lordship will kindly page 5 of the judgment, at 11 page 13 of my memo appeal, and the running page of the judgment is 5. My
Yes.
lordship will kindly say page 5. At the bottom from the middle, I am reading from the middle. This in 1, 2, 3, 4, 5, 6, 7, 8. From the bottom, line number 9. This implies that there was a criminal enterprise enrolled. This is the observation of the RCT. From the record, we find that an application under section 18(3)(b) of the RCT 1987, due to 20(b) of the RCT procedure rules of 1989, was filed by the applicant to production of the forwarding note, loading telebook, original rail receipt, seal and card labels of destination point, copy of unloading tally and delivery deficiency message of destination point, and all records about the movements of the wagon during the railway transit, and respondent was directed to produce the documents called for. It appears that except the original railway receipt, other documents called for by the applicant has not been produced, and explanation had been furnished by the respondent for non-production of the document called for as per section 64 Railway Act. Every person entrusting any goods to a railway admission for carriage shall execute a forwarding note in such a form as may be specified by the central government, and the concerner shall be responsible for the correctness of the particulars furnished by him in the forwarding note. A perusal of section 64 of the Act goes to show that forwarding note is in the primary evidence and railway receipt is secondary evidence, as railway receipt is prepared on the basis of forwarding note and not otherwise.
Mr.
Further,
Chakravarti, you see, omit this reading. That doesn't take us anywhere. Number one, it is your authorities who are giving a certificate that the top and bottom seals are missing. If you don't supervise the sealing, if you have no record of sealing, why will your staff give a report that the seals are missing?
only I have given the shortage certificate. Shortage is
No,
there.
no. She has shown us that document. Don't ask me to read that again. I read it once, it's good enough. There is a certificate that these seals are missing. Now, why did you give that certificate? And if the officer of the staff, railway staff, who has given that certificate, have you terminated his service?
No, my
Have
lord.
you shown before the tribunal that this man was not authorized to give that certificate? He has given it, we have terminated his service. No.
My lord, at the, when the railway receipt was issued by the railway staffs, my lord.
I'll just give a simple example. It is easier for me. You see, this pencil existed when it is here since the morning when I am sitting. Correct. Now, there is an allegation by you saying that you dropped the pencil yesterday and I picked it up and I have kept it on my table. That is the allegation.
Yes.
Now, to prove that, what will you do? Because this Apsara pencil is with everyone. Now, how would you show that this is your pencil? Correct.
Yes, correct.
And if I give a certificate saying that, well, Mrs. Chakravarti has lost her pencil, that means I take responsibility of knowing that you had a pencil and it was lost in the
Yes,
courtroom.
I
Correct.
should have a knowledge.
I have a personal knowledge. Now, how will your officer or your railway staff give a certificate of the seal being missing if there is no proof of a seal?
Yes, but in railway receipt, my lord, as per our ground 6, my lord, I have taken that. The
The grounds are okay.
my lord, reflect the outer packing not
Mrs.
complete.
Chakravarti,
Packing condition
Mrs.
must
Chakravarti,
means-
you see, I was once there. I know how to make grounds.
I know, my lord.
It is with that
I know.
experience I have come here.
So, my lord,
So making grounds is okay.
so, well,
The
as per section
Post
90,
retirement, if you give me one paragraph, I can make 100 grounds out of it.
actually section 94, my lord, when
No. You see, come to the facts first.
Yes,
Grounds
my
will
lord.
come later.
and that's it is written the seal was not there. It is that.
So you see,
but
your railway receipt goes. This Sharma is right to say that the veracity of the contents of the railway receipt goes.
my
You
lord,
can't have a contradictory document on record.
my lord, here, my lord, when the packing was not there, not supervised, loading is not supervised by the railway staff, and at the forwarding station and
So you want to
unloading
say,
of the consignment
Correct.
destination station also not supervised.
so
by the
you
railway
want to
staff.
say that the Indian Oil Corporation, which is one of the Navratna company, it fraudulently entered what you call kerosene in one of the petrol tanks with an intention to cheat the railways, which is again a government organization. And then when the railways were carrying this was siphoned off by this Indian Oil Corporation to make unlawful gain.
But since the was
No,
consignment was
I
received,
can understand that you accuse a businessman.
no, there is no delay in transit. So for question of shortage, no scope of criminal interference is there. There is no any documentary evidence for
Okay,
showing
where
the
is the
criminal
seal?
interference. So
Why-
who is broken the seal? Yeah, if they,
No,
it
that
is seal
question
was,
itself is an answer.
yes, who is broken the seal?
So the seal is there.
No, seal, without seal, like wagon cannot move.
It cannot travel. So now you see.
So once seal was there,
Now you
then there
understand.
is no any criminal interference,
No,
then
no,
who is broken the
No,
seal?
Mr. Chakravarti, now you understand the art of cross-examination. Now it has come out from your mouth that the railway cannot travel without a document, without a wagon being sealed. Therefore, seal is there, whether you supervise or not. There's a requirement of seal with there. And you have certified that the seal is missing. So please tell us how it went missing. You were the owner of the vehicle where it was being transmitted.
Yes, seal was missing, though we are not supervised this concept, whether there was seal or not, it was loaded or not, seal was in intake condition or not. But there is a shortage, they are claiming there is a shortage of kerosene oil.
Can
So,
you use this?
now, as per their,
It be dismissed then.
since we have issued the shortage certificate, it already it is observed by the Honorable Odisha High Court, my lord. When their shortage certificate or railway receipt were no help in this regard. Though since it has not supervised by me, I have not loaded, I am not unloaded. It is unloaded by the private party in private siding. And section 94, my lord, it is already clearly
No.
tell that. Section 94.
You are missing a sequence in between. Because there is a shortage certificate would mean that somebody in the railways were aware that there is a shortage. And
Yeah. In section 94,
you see, that certificate issued when?
at destination station at the private siding of the consignor.
Okay.
The
So
only
therefore, this certificate is issued by whom? Shortage certificate was issued by
by
whom?
railway.
By the railway.
Really, when just as they have accepted the weight at the time of issuing of the railway receipt, they accepted this loss at the time of delivery of the consignment, whatever the consignor stated. So
You found the
only
document?
we have
Lordship,
accepting their here.
That document I cannot see, my lord, in
But
the
Lordship
records,
will
but my
kindly
lord,
see
in the
94.
railway
Okay, just
receipt,
a moment. Just a
because my
second.
lord, in the railway receipt, there is a remark load condition fulfilled, which says, my lord, that we have complied the
Loading fulfilled.
conditions of the loadings, my lord. Which also says that, my lord, we have also sealed the wagons, my lord. Without seal, my lord, the consignment cannot arrive, my lord.
On
No,
the
it cannot move out. Arrival is something else. Don't confuse
The wagon also,
the movement with arrival.
yes, my lord, wagon.
Because if it is
cannot-
arrival, then you lose. Then it is your responsibility that the shoes must be there in the
Yes.
time of arrival. Arrival is not the issue.
My
It's a
lord,
loading and dispatch, not arrival.
but Lordship is only
Yes,
saying,
Mrs. Chakravarti, please continue.
section 94 of the Railway Act.
Yes, please
A
proceed.
goods to be loaded or delivered at the siding not belonging to a railway administration. This is a private siding of the IOC. Where goods are required to be loaded at the siding not belonging to railway administration for carriage by railway, the railway administration shall not be responsible for any loss, destruction, damage, or deterioration of such goods from wherever cause arising until the wagons contain the goods has been placed at the specified point of interchange of wagons between the siding and the railway administration, and a railway servant authorized in this behalf has been informed in writing according to by their owner of the siding. So in here, my lord, now the consignor being a owner of the siding has not.
No, you have missed out a word. You please give stress on one word. In the third line of that which you are reading,
The railway administration shall not be
section
responsible.
4, so and so, fourth line. Whatever cause arising, then there is a comma. Then
Yes,
there's a word until.
the wagons contain goods.
There is a comma. Then there is a word until.
Yes.
Until means that until somebody tells the railways, that means liability is there. 94 does not say there is no liability. 94 says that the liability will arise and it will not arise until you tell us.
Until the wagon contain good has been placed at a specific point of interchange of wagons. It is railway shall be responsible on that point when the wagons will be interchanged in a specific point. Interchange of wagon between the siding and the railway administration. Here there is no interchange of the wagon between the siding and the railway administration.
Okay.
Since the wagon has not been interchanged between the siding and the railway administration, the railway servant also not authorized. So in this question, how the railway will be responsible? So section 97 also, goods carried at owner risk rate. Notwithstanding anything contained in section 93, a railway administration shall not be responsible for any loss, destruction, damage, deterioration, and non-delivery in transit of any consignment carried at owner risk rate from whatever cause arising, except upon proof that such loss, destruction, damage, deterioration, and non-delivery was due to negligence or misconduct on the part of its servants. So in this case, it was loaded by the consignor, unloaded by the consignor. Railway has not supervised. Whatever they informed the railway staff, it was included in the railway sheet, and whatever they inform about the shortage or loss or damage, railway have accepted this their statement. So, my lord, in such situation, the issuing of the shortage certificate or damage certificate by the railway staff, it does not help in this regard. Because I am not responsible. It is loaded by the consigner and unloaded by the consigner in his private siding, not in the railway premises, railway siding. So there's another.
So if I am not responsible, why will I give a certificate in the first place?
My lord,
If I am not responsible, why should I give a certificate for the first place? Your railway staff who is not responsible, why will you
As,
give?
since it was carried by the railway, as railways, or it is mandatory for the railway to issue railway receipt, except in the forwarding note. As is when they are claiming the shortage, it is also mandatory for railway to issue the shortage certificate. But burden to prove that occurred is always on the consigner. They are saying there is a criminal interference in the and road.
You have a manual with you. Yeah, I
But
have seen
there is no
manual.
any evidence.
my lord, section 93 is very relevant, my lord. Responsibility of the railway administration
I
as
wanted to
carrier
s-
of goods, my
I
lord.
wanted to see that provision for issuance of shortage certificate in the IRC manual.
It is available in the railway website. May I see, my lord? From there?
It shows that that relevant part, Ms. Sharma,
Yes, my lord.
about this railway ceiling.
Lordship's own orders, my lordship already observed that in MFA 272 of 2010, then para 25, the learned counsel of the both sides have referred to the various cited cases. The cases of Jyoti floor mills is held that court that the railway administration to be assumed as liability under section 73 of Railway Act equivalent to section 93 of the Railway Act. It is necessary that in the forwarding note, not only there should be a recording of the fact or on defective or improper packing of the goods, it should be further recorded that as a result of such defective or improper packing, goods are liable to be damaged, deterioration, decay, or wastage. In the opinion of this court, the said finding is a treaty law in the subject. Therefore, in the opinion of this court, the burden lies on the respondent to show that there is a pilferage of the goods and road. If there was an evidence of pilferage, then the Railway Act provides for open delivery under section 81 of the said Act. In this case, said provision not taken recourse to. Therefore, at this stage, it should be responsible to whether there was evidence of pilferage in the so Katha rice transported by the appellant. Hence, the reference in the aforesaid case is not
You are
found to be
reading from
helpful.
where? You are reading from where?
In my lordship's judgment dated 21/3/2013, passed in MFA 272 of 2010, already I given my
21?
21/3/2018, passed in MFA 272 of 2010.
Paragraph?
Paragraph 25, 26, my lord, 26, and my lord is the 20, my lord, 20. Well, in this para 20, the lordship will clearly observe that in the claim petition para 20, the respondent had mentioned that at the time of unloading, they found the wagon seal card label were absent and the door having big gap and the stake were in disturbed condition and the wagons found in a broken and damaged condition with a cart hole which suggested criminal interference and road. And that shortage of consignment was recorded in the unloading telebook. While the learned counsel for the respondent, he stated that has stated under the provision of Rule 1714 of the IRCM Volume 2, requiring that seal and label should be carefully preserved for 6 months, then destroyed. But in the case of shortage from wagon, dispute of claim, they should be submitted with the means and damage goods report. In the present case, in hand, goods are booked on so and so. The date of delivery was not mentioned as a claim petition, and the request for issuance of short delivery was made on so and so. followed by notice under section 106 of the Railway Act, which was served on the NF Railway 61/2000. The present claim petition was filed on so and so. The pair of calling record was made on so and so. Therefore, unless within the prescribed time of 6 months, the railway administration is requested to preserve the seal and level, unless the order is passed by the learned tribunal to show whether such seal and level has been preserved or not, the railway administration was under no obligation to produce the such seal and levels for examined by the railway claim tribunal. If it is one thing to show, follow the rules 1714 of the IRCM volume 2, and it is altogether different matter to produce such record before the learned claim tribunal, merely because railway had no notice to produce card and seal level. It is not open to the learned tribunal to jump to the conclusion that railway did not follow 1714 of the
It's okay, okay, okay. Ms. Sharma,
My lord, 1725 to 1732 rule, IRCM rule. Starts.
no, you see in your letter, there is a reference to IRCM volume 2 of 1991,
Which letter, my lord?
16/9/2009. Now, just note in your, there's a reference in this to card and seal that rule. IRCM volume 2 of 1991, rule numbers 1570, 1578A. Just note it.
Yes, madam.
I won't be able to repeat.
1578A
A 1713,
and 1714.
1714.
Yes.
Is there any other
Yes, madam.
rule relating to IRCA you produce on the next day?
Yes, madam.
You fix it on Wednesday. The submissions of Mrs.
4 October.
Chakravarti Leonard, Senior Standing Counsel for the the arguments, the submissions of Mrs. U. Chakravarti, Counsel for the Senior Standing Counsel for the NF Railway, and Ms. M. Sharma, Counsel for the respondent, remains inconclusive. Next paragraph. The learned counsel for the respondent shall produce photocopy of the relevant part of the manual relating to seal. The learned standing counsel for the appellant shall explain the meaning of inverted commas, okay packaging condition, outer not compliant, inverted comma closed. Which is a remark contained in the railway receipt. List again on what is it? 4/10/2023.
Deep privilege.
The hearing is almost complete. We will not hear on that day.
Yes, sir.
Only that.
I will provide
add
that.
manual on
Yes,
this.
sir.
Have to submit the meaning of this. Or okay, taking conditions, not comply, outer not comply.
We have a lot of people in railways. Somebody can explain that.
Yes, sir. Yes, Lordship.
First appeal, my learned friend has prepared a paper book, my lord. I think, my lord, it will also take up to take time also. Paper book, my lord, he has translated all the evidence, everything, all documents has been given, my lord. You will submit a copy to the court also. It
No,
will be
because you
easier
see,
for
there
the-
are all matters. We are under immense pressure
Malad,
to
Tuesday.
start the hearing.
That's correct, my lord.
Tuesday, no, Tuesday we have an election matter pending.
Okay.
On Tuesday, nothing is going to happen.
I can start, my lord, but only judgment can be read, my lord. It's not that way. Because it will take time, so.
This first appeal.
Today we
First.
today can we start?
If you lordship one, my lord, I can counter missing the judgment, my lord.
Up to lordship, not if lordship wants to hear, better can we started this?
No, because you see, we are always having this in this bench for some time. It will be on the top of the list. We are having matters. So, if you want a entire what you call reserve day for hearing, that I think in
Not possible.
short time is not possible.
So my lord is sitting probably in all the dates, my lord, with criminal
DB,
matters,
that is a
division
DB.
bench also.
Partly DV and partly the
Partly.
regular bench.
That,
So
that, my
therefore,
lord,
any day we start,
It
we
will not
presume
complete.
that it will not be completed. So it depends on you. Because all matters are there, I am not adjourning it.
that's correct.
I mean, we are sitting also for that purpose, we are not seeking adjournment.
No, then we begin with it.
May I place the judgment, my lord?
Yes.
My lord can, my lord, paper book I am,
My lord, I have received the paperwork also, my lord.
Your suit was dismissed.
My lord.
Basically, issue 4 and 5 were decided against you.
Yes. 4, 5 and other three also, my lord, they regarding power.
4 and 5 are main. 4 and 5 are main.
basically 4 and 5. One is, my lord, that the suit is not maintainable in the present
This is
form because of, my lord, the power of attorney.
That we are not going into it at this stage.
But there is a decision of our, my lord, division bench also on that.
On power attorney.
Power of attorney is not a public document.
No, that is correct, my lord.
So certified copy is not admissible in evidence unless and until you take recourse to section 65.
But here the owner himself, my lord, examined himself.
So anyway, I'm just giving a
I shall.
that is the issue.
Was it based on that judgment of a bank?
No,
Was it based on a judgment by the bank?
no, this was in a case of Narottam Das and others versus Masadar Ali Bhuiyan, where the earlier judgment was, my lord.
What is it?
Is this based on a Supreme Court judgment on bank?
Now that is a case, my lord, they relied on a, my lord, Privy Council's case of 1943. No, it was printed both sides, my lord. I'm sorry for that. It was printed both sides.
Yeah, it's okay. When it comes to paper, I am more stingy than anyone else.
But sometimes
Look, you see, this is how I work. Because this,
Yes.
I use this for writing. I'm too stingy when it comes for wastage of paper. But there are two theories operating. One theory says that I'm absolutely wrong in doing it.
Well, we also use ballot also.
There's a theory operating for that also. When somebody is doing a work of brain, you must do it in a clean state. That is one theory operating. If you don't get distracted, you write in a fresh piece of paper. But I have converted myself because of one incident which happened. When I was a college-going student, I received a letter from someone, the authority, and that letter was given in a envelope made of newspaper. And there was a message written in that letter that this is done to save paper. So since my college days, I'm very mindful of wasting paper.
We normally use in the chamber melod the papers which are melod ultimately disposed of.
It's something a choice. It's a
Always
matter of
melod.
choice.
Because of we always use.
For draft melod,
At one point of time, it triggered into my head. I made it a habit.
In some of the high courts file both side print. In some of the high courts, both side prints are.
Here also we are permitting it. High Court rules have been changed. High Court rules have been amended. Now you can give both side printing.
Both side.
Huh?
In court also.
In court also.
We are in the habit of printing in one side only because
It is for the convenience, but now the High Court rules have been amended to include.
yes, my friend is saying this is yes.
It saves paper.
I didn't think.
This was a PL moved by Advocate Ms. Anita Verma. Court accepted it and then we both side printing. It's permitted now.
But the judgment is at page 176 of the paper.
But I'll tell you, I have read a judgment.
Yes.
I can't remember it right now. You see, why it becomes a public document? The judgment, I just can't remember it right now. You see, when a sale deed is given for registration, what actually happens?
They copy in the volume.
It is recorded in the volume book.
Volume. And
when certified copies are issued, it is a certified copy of what?
Volume.
It's a record of volume. Therefore, it's not a private document which is being given to you. And therefore, there is a judgment which says that since it's a record of a public record, it would be admissible.
But in this judgment, we don't.
No, I know.
No, I'll try to find it out.
You'll get it.
I have not been able to load yesterday. Couldn't get time, but I'll try to find it.
Because it's an extract of the register, which is again
that is a public document.
But this I had been searching of a few judgments for another purpose. While sitting in division bench in a criminal side, I was examining the issue of the postmortem report not being a public document. So because postmortem reports, they are not entered into a public record. And it is called, because from the research I did, I could understand. I don't know whether it is right research or wrong. But what I gathered was when a dead body is sent for forensic examination by postmortem examination, there's a GD entry made. And it is on the strength of GD entry, a police requisition is being made to the government hospital to do a postmortem. And therefore, it is in compliance with the police requisition that has been done. And therefore, it's not a record of, it's not a public record. It's a private record.
Oh, postmortem will be
It's a private document. It's not a public document. And that is the theory why I was searching. I got this judgment because of my that once it is entered, then I found out that the postmortem report is not entered into a public record. It is issued from the medical college. The origin prepared in 3 volumes, and it is sent to the police. I said duplicate, I think. Postmortems are in duplicate.
duplicate.
So it is sent to the police. Records are not maintained for that. Last week, in fact, I was doing a research, so therefore, this is something which is fresh in my mind. In that course, I found one judgment which says that it's a public record because it is coming from a public document. A register is a public record.
And look into it.
No, but I don't know if this is a division bench judgment. It may be I may be bound by this. That judgment I just forgot because it is not a relevance.
If the lordship can give an indication, we can try to find it out.
No, because very hard to say. I was looking at few judgments, and since I was doing research online, I won't be able to recollect anything.
Anyway, we shall search.
Huh?
We shall search.
Yes.
Well, page 176, the judgment, madam. Page 177. Brief factor of plaintiff's case. The brief factor of plaintiff's case is that plaintiff is the manufacturer of PSC poles of 7.5 meter and 8.5 meter, which is manufactured for the purpose of laying ACB power line in rural areas under the scheme of the central government as well as state government to provide electricity connection to each and every house in rural areas. The plaintiff's son running and managing the business of PSC poles and duly authorized and empowered attorney to manage the business as well as file suits, etc. for and on behalf of the plaintiff. The defendant number 1 is the private limited company established by the defendant number 2 and 3. They have obtained contract work for supply line PSC poles in rural areas in different districts of within the territory of Assam under the Central Assam Electricity Distribution Company Limited. The defendant from time to time placed orders for supply of PSC poles height work order number so and so and so so and so. As per norms, manufactured PSC poles to be tested by ACB officials and on delivery and issue of the road challenge of the goods which is received by the defendant's officials from the manufacturing site, which has been carried to different project sites. As per order by the defendants, DSC poles 500 number 7.5 meter and 1150 number of 8.5 meter is manufactured by the plaintiff, and the same has been tested by the officials of the ACB. And after delivery of the PSC poles, the plaintiff submitted bills as per the terms of payment. 40% will be released immediate after testing and dispatch clearance materials, and balance 60% payment will be made after the goods within 30 days. Out of 500 number 7.5 PSC poles and out of 1158 so 578 number of though tested by ACB, same was not lifted delivered by the defendants, have failed and neglected to clear the previous balance of rupees 11 lakh and odd. And as per the terms and conditions of the order, the defendants are to pay the amount within 30 days, but fail when you send the demand notice letter so demanding 24% interest. The aforesaid PSC poles are manufactured and tested 578 number of 8.5 meter and 500 number of 7.5 meter. The aforesaid PSC poles are manufactured by Mrs. Chandawala Construction Private Limited, but due to non-payment of huge amount, those PSC poles have been diverted to the defendants and with written consent of the SEB filed letter number so and so. If at the time lying of the PSC poles, the defendants labor mishandled the same and caused damage to the PSC poles, then certainly the plaintiff is not at all liable for such damage. The plaintiff served demand notice number so and so, that 8, 9, 10, and 26/10/2010. The same has been received and they on so and so replied, taking the plea that poles supplied was FOR destination, at site. As such, the defendants are liable to make payment of the price of manufactured PSC pole, which amounted 8.5 meters, 578 number pole, and 7.500 poles, amounting to rupees 20 lakhs and odd and 13 lakhs and odd, plus previous balance of so and so 11 lakh, total 45 lakhs with interest 18%, as per section 61 of the Sales of Goods Act for 8 months. That is 543, 563 total 50 lakh 73,257. The plaintiff inquired in the office of the SCB and found that the defendants have received the bills of the supplied PSC pole. If the poles are damaged, broken, then certainly SCB shall not release the amount of the damaged, broken PSC poles. Hence, the suit. On presentation of the plain money suit number so and so registered and summons has been issued to the defendant number 1, 2, and 3. Defendants on receipt of the summons made their appearance and submitted their written statement, whereby they have stated that no cause of action arose to a suit. Suit is not maintainable in the present form, and this court has no jurisdiction as per contract. Suit is bad for defector parties, barred by limitation, barred by principle of waiver, estoppel, and acquisitions, and bad for multitudinous cause of action. Such so-called attorney of the plaintiff has no right to file the suit on behalf of the plaintiff. The suit is barred under Order 30, Rule 10. Averments made in the plaint are vague, self-contradictory, and defective in material particulars. Plaint is not properly signed, verified, and presented, and not supported by any legally shown affidavit. It is stated that the defendant company on 399 issued a final letter bearing office memo number so and so, the September 3rd, 2009, for supply of PSC pole for the defendant Lakhimpur package under the Assam East Board. In the said letter, all the terms and conditions for supply as mentioned, and the plaintiff accepted the said terms and conditions, accepted the offer, and finalized the contract for supply. Out of the terms, the conditions entirely are the following clauses of the terms of contract. The price of quantity is inclusive of transportation cost up to site. If the poles are found broken, damaged at the time of delivery, all have right to impose liquidity damage of 5% per week of delay or part thereof, maximum 5% value undelivered then. The raw material inspection will be carried out by our client, third party, us at our work, your works, and after approval of the raw materials by our client, third party, us, he will command the production activity. The final product shall also be inspected and treated and approved by our client, third party at your work. You will strictly follow the respective quality code so and so specification during the manufacturing the poles. Defendant stated that plaintiff has not observed the above mentioned clauses, though as per terms of the contract, the plaintiff ought to have unloaded PSC poles at the site, but plaintiff unloaded the poles in a very distant place from the work site, which caused the defendant's company to increase heavy expenditure for shifting poles to the work site, which is about 12 to 30 km distance. And as per the account maintained by the defendant's company, it shows that expenditure of rupees 11,33,000. The defendants time to time themselves and through the power of attorney submitted bill to the plaintiff company, but plaintiff unloaded the broken and damaged poles, and at the time of lifting the pole, the poles broke at the middle. As a result of which, authority informed these defendants regarding sub-insurance poles supplied to the plaintiff, and the said poles are rejected according. The defendants immediately informed the plaintiff and requested to replace the same, and the plaintiff has not done. Due to the damage of the correct pole supplied by the plaintiff, it caused a heavy loss amounting to 6,75,000 to the defendants. The defendant informed the plaintiff several times over telephone and issued letters, and although the pleaders also the pleaders notice, the plaintiff does not respond to the request for negotiation. The defendants were always ready to settle the dispute by negotiation, but due to hostile attitude of the plaintiff, the defendants have no other alternative to file the suit. So the defendants filed a separate money suit for recovery of rupees 19 lakh and 6,000 only against the plaintiff and paid for dismissal of the suit. Then issues are cause of action, maintainability, jurisdiction, then defendant violated terms and conditions of the work order, and whether plaintiff supplied unrelated damage to upon force. Well, 4 and 5 are important. Well, issue number 1 and 2 is decided in our favor. Well, I'm not placing the same. Issue number 1, 2, and 3.
We decided.
Huh? Oh, sorry. Who is that?
The decision of the trial court on this issue number 2, wherein the power attorney was held invalid, that would not be maintainable. That has to go because of the fact there are two things. Number one, a specific issue was not framed. And the specific issue was not framed, coupled with the fact that in written statement, specific plea was not taken. You did not say in the written statement that the power attorney copy was inadmissible because along with the plaintiff document contains the power attorney. Before we fall back on that case of Dijendra Nath Lahiri. You've seen that judgment? Dijendra Nath Lahiri. Because in the written statement you have said the power attorney did not involve him. That is the only thing written. It doesn't say that the power attorney was otherwise invalid. The copy given was not sustainable.
But that issue cannot arise at that point of time because the power of attorney was given.
No, that copy is there.
Copy is there.
Huh? So you know what is filed, but that plea is not taken. So
no,
you see,
basically the plea was that the certified copy is
no, that is okay, but it came at the time of cross-examination. So therefore, the court had to give them an opportunity to bring the original. That's what I am saying. The Dijendra Nath Lahiri. I don't know about the others. 4 and 5. Mr. Sayala would have to argue, but so far as this is concerned, there I think it would that part of the decision would warrant interference. Jitendra Mohan Lahiri.
Jogendra Mohan Lahiri. Jitendra Mohan or Jogendra?
It is Dijendra, DWI. Dijendra Mohan.
Oh, Dijendra Mohan Lahiri.
Dr. Dijendra Mohan Lahiri.
It was an old case probably.
It's a decision of 1971.
It's an old case.
Division bench.
1971. Dijendra Mohan Lahiri.
Yes.
Okay.
Paraton. By division bench.
AR 1971 AR Guwahati 1.2. AR 1971 Guwahati 1.2.
Moreover, my lord, here.
Because here also on the guise of maintainability, something like this was decided.
Yes.
In this case. Therefore, the court says that you can't have a vague issue and then decide something else.
So otherwise, that is, in several cases, that vaguely you take question of maintainability
Huh.
without saying anything.
Without saying anything.
But that is, otherwise can't be.
Huh.
Because you have to specify why it is not maintainable.
Yes.
Because the other side will get an opportunity to lead evidence to that.
Huh.
Yes. Well, here, moreover, here, the author of the power of attorney, who is the owner of the plaintiff, he himself examined the period one. And he said that because he was in charge, my son is in charge of the, so I have given him the power of attorney, and he is looking after that. Here, that is also there. Author of the power. Now I shall place my lord issue number 4.
Because 4 and 5, so far as I have understood, vaguely reading it, is that the goods were supplied. Somebody made a complaint that it was not of good quality. And then the court gives a finding that it was a requirement that the pipes would be supplied to the purchaser. But it was not supplied in the purchaser, it was supplied midway. And then additional costs had to be incurred. And then there was a destruction or part destruction of the pipes.
Yes.
And therefore payments were not made. But there I don't find the clinching evidence on in favor of the plaintiff.
Yes.
To make him entitled to any payment. Because if the goods are not there, goods are not taken. But what I did not find here is that what happened to the goods supplied. Pipes were supplied. What happened to those pipes, I don't know. There's nothing on record. I did not find it.
We have evidence that they have supplied to the ACB and they have got the payment. They have got the payment.
Payment was received.
Received by them.
But that evidence is not there.
Not there.
No, that
Plaintiff said, my lord, that is there. Plaintiff said that we have supplied, they have received the payment from the ACB, they have supplied the goods and they have received, but nothing has been placed on record as an evidence that in fact it was happened or not. That was the pleaded case.
No, because I tried to find out is the goods after being supplied, damaged goods. What happened to the damaged goods is not there. Because then you see, if the goods have been consumed, then if that Mr. Saivala can show,
yes,
then we can always go back to the provision of 71
Contract Act.
Contract Act, saying that it was a what you call a non-gratuitous act, and therefore otherwise you will be liable, because in that regard there is a judgment of this court also. Because even if this money suit otherwise fails, 71 or 73, what is that?
71, I think. 71.
Non-gratuitous act.
71. Not 71, not 71.
71 or 73?
71, not 71. I'll just place it because I remember that.
Either 71 or 73, either of the two.
73, not 73. 770. Obligation of person enjoying benefit of non-gratuitous assent.
70. Okay. $70. So if these goods are converted into your goods, then perhaps even the appellate court would have the what do you call, that is a view which the appellate court can take. Because in your evidence also you don't say anything. When the goods you don't accept, then goods has to be returned. The return part I did not find.
No, but not your lordship will kindly see. I'll come to let him argue whether the goods were received by us or not. That is not true.
No, that is not denied.
Huh?
That is not denied.
No, that is denied.
No, because you take a plea that it was damaged.
No, damage plea is there. And in some of the
Denial I don't
challenges,
find.
in some of the challenges, your lordship will find.
No, denial I don't find. Come to your written statement. This is something I did not find.
Right.
So that is why the strategy which I had in mind.
Huh?
Having not found that, because you see, we don't have time to read it thoroughly. It is just a cursory reading.
No, I'll read and place it.
Because that denial, if it is there, then I don't know, because this is something I missed. If the denial is not there, then what I propose is that in view of section 70, we demand the matter back to the trial court to also examine where the goods are not returned. The enjoyment of gratuity
The
act
matter
is
can
there.
be remanded to the trial court and the trial court will take it.
On that point only, but subject to, if you can show me the denial is there, then the burden shifts on Mr. Saiwala.
I'll point it out. I'll point it out. In fact, no bills were raised. As per the terms and conditions.
No, bills were raised, 51 lakh or something.
No, my lord, what they say, your lordship will kindly see. They are paying 50 lakh and odd. Now, my lord, they say that there was an order for 500 7.5 meter poles and 1150 pieces of 8.5 meters. These were the orders, and that order is exhibit note A that was put in cross examination to him. And that, my lord, terms and conditions are there. That we have taken the plea. Now, the jurisdiction is also vested in the Jorhat court. I'm just pinpointing to my lord. Now, my lord, in that, my lord, their case is that my lord, we could supply. They have not supplied 7.5 meter, any a single piece. They have not supplied 1150. Rather, they said 578 pieces were supplied. That is their case. Rest, they say that they have not lifted. But since they have not lifted, it was made for them, so they are liable to pay us for that. And accordingly, that amount has been added. That 507.5 meter. And 572, 578, 8.5 meter price has also been taken into consideration, and they say that they are entitled to 50 lakh. But rather, in their evidence, they have admitted that no, since they have not paid the earlier payment, we have not supplied, we have not given the goods.
Okay.
So they are not entitled to 50 lakh. Now the question arises for consideration whether 11 lakh. And our case is that you have supplied defective goods. You have supplied the goods 12 meters, 30 kilometers away. we have to carry it. So we have incurred around 11,30,000, and 6.7 lakhs is the amount for damage and all that. Now we say that you come forward. That is our case in the period case also, that we call them for negotiation, that come and sit.
So then the court did not accept trial court saying that you did not file a counterclaim.
We did not file a counterclaim. That is true, my lord. But my lord, a separate suit has been filed in Jorhat, and that suit was, my lord, to my knowledge, that is in the evidence also, that was stayed by the trial court there. Because they must have filed an application that another suit is pending. I do not know, because both the suits are different. Why that suit was stayed under section 10 probably, my lord. And what is the position of that suit? My lord, I have not been able to find out. But online, yesterday we have seen online that suit, they say disposed of dash state.
So Mr. Savara, you can concentrate only on issue number 4 and 5.
Yes, ma'am.
With your evidence.
Yes. My challenge copies are there. They have next here. You can also see page 100 onwards. Only in one challenge, my lord, they have shown the recording there. These challenges, my lord, are there. All the challenges they have received it. But also only find at page 110 at 111, my lord. It has been said. Number received in good condition, and 17 number is for reject.
One more challenge, there is an entry that one pole damage.
Yes, one pole damage.
Yes,
one pole damage.
One pole damage. So what they say, my lord, that's correct. Yes, that's one pole damage.
Page 104.
104. So, my lord, actually, not much, my lord. As per the documents, so 30 number only. 17 number and 18 number. Only 18 number.
In page 111, there is another challan. It says that 12 notes received in good condition. The rest, my lord, 29 rejected, 41 returned out of 70.
This is in respect of 110.
Yes, 110.
29 are rejected.
No,
29 rejected. My
no,
lord,
17 number, my lord.
17 to in good condition.
12 number.
12 number
in
received.
good condition. 17 numbers
Rejected.
PSC power rejected. Total 29.
Then below, my lord, 41 pieces returned. Total 70 pieces.
41 piece return.
And in some of the challans, my lord will find there is no one's signature is there who received it.
No, signatures are there.
Signatures
No,
are
in
there.
not in all. Not in all.
Signatures are there.
Signature, that question was.
Signature is there.
That question was put in cross-examination. In some of that signatures are there. They say that these are not our people. 100, some Dharmendra Sonwal.
Yes.
One is Dharmendra Sonwal, other is by someone. Signature
101,
eligible.
101, no receipt.
No, receipt
receipt
is
is
there,
the right side.
but with seal.
Huh?
With
With
seal.
seal. With seal.
Oh, okay.
Some Jay Sharma.
Ah, yes.
Then again, somebody received.
Ah, yes.
Samua. Third one. Fourth one again, Dharmendra
Dharmendra
Sonwal.
Sonwal.
Next is Sanku Saikia.
Yes.
Again, there is a eligible signature. Next,
Yes. You can see. It will received as
here again T Saikia or J Saikia.
Yes.
Next. Again J Saikia.
Received.
J Saikia.
থাকিব পাৰে দেখা নাপায় আছিল লাগি 100 পিছত আছে না 1111
You are saying that 7.5 meter was not supplied.
not supplied at all. That is their case. It's not our case. And they have admitted 7.5, they have not supplied a single piece. Their case is that 572, 8.5 meters poles were supplied. And I have calculated yesterday, my lord. The challans also, my lord. If your lordship calculate, it comes to 572.
But come to page 133.
Yes.
I think other matters will not be taken up today. We won't have time. One 133 says it's a test report of 7.5 meter.
So this is the order, my lord. This is an
No, it's
order.
a test report.
Huh?
It's a test report.
Oh, I'm sorry.
It's a test report.
Oh no, this is not our company. It was somebody else. This is the Chandalaya Construction Private Limited. Actually, they say that we have manufactured for them. They were not paying the money. So we took the permission from ACB and diverted the materials to you.
Okay.
These were inspected by ACB officials. Inspected by APDCL officials.
And
I think
one,
there's something wrong. There's something wrong. We come to page 169. This is to wind power. Wind power. You are wind power.
I am wind power.
Now you see, with reference to so and so, both first line, so and so purchased from you, from Misapol Industries. That means the 8.5 and 7.5 are both admitted by ACB.
No, earlier supplies were also there, my lord. Your lordship will kindly say this is not the only supply. There were earlier supplies also. They have not referred to the, my lord, which order. But I am saying, my lord, this is lordship. I also from the record also. There were earlier orders.
This is
My lord, this 1150 and 500 was the order exhibit A, my lord.
Okay.
It was earlier. It is not that, my lord. I have given the ledger. Earlier transactions were there from 2009.
From 2009.
Your lordship will kindly see the ledger, my lord. Page 1. Hmm? 145. Huh? $145.
Okay.
There was no outstanding so far my lord earlier is concerned.
The present transaction is from which year, which period?
2010.
2010, the order was in excess 85. Chalan chale bola na. No, no, chalan chalan. These are supplied in my lord March, April 2010.
March, April.
That is they say, my lord, and your lordship will find the order exhibit A is of 1/3/2010 at page 134.
Yes.
1/3/2010.
Yes, 1/3/2010, the orders were placed.
So please come to 146 and then reconcile that.
146. Yes, my lord.
This is whose ledger? Your ledger.
Yes.
My ledger.
This is your ledger.
My ledger.
Then Sarvata, there will be a huge amount of motion you to show us.
Correct.
You see, if this cross-examination is correct at page 41 onwards.
My lord.
Before that, let me show you page 30.
30.
30. 30 paragraph 9.
Yes.
Defendant is liable for 8.5 meter.
Yes.
So and so poles. And so 8.5, Mrs. Agarwal is saying that you have never supplied.
Yes.
So 500 posts amounting to so and so, previous balance of 1148,894. Correct?
Yes.
So previous balance of 1148. Now come to a cross examination.
Yes.
The copy which we said, right? Page 44.
Right.
Second line, as per my balance sheet, I am still entitled to 11,48,000. So and so.
Yes.
So therefore, your entitlement is only 11,48,000.
Rest well, they did not supply because they stopped. I shall take again well.
Huh?
I shall again take instruction matter in this second. Not take much time. It appears 11. Rest was not supplied.
Where is your agreement? Is there any terms and conditions of supply? Where is that?
Page unit A. 134, I think.
130?
134.
Three.
Then that condition is not there, the supply is not taken, then you will be liable. That agreement is not there.
No.
Sort of. No, the
That
agreement-
condition is
that
not there.
condition is not there.
That is not there.
So
If it is not there, rather my lord will
so
kindly
in
see.
terms of, no, in terms of economics, I am saying that out of 50 lakh, 11 remains, 39 goes away.
Huh?
39 goes away. So 11 remains. Now we'll be fighting for 11 lakh.
11.
Yes. Correct, because that other goods has not been supplied because they did not
Best
pay
portion
them.
is there, my lord, both the parties can sit together and settle the matter, my lord. We have given the offer earlier also, even in the plaint we have stated so. But the dispute can be settled. Where is the dispute, my lord? Question is that we are entitled to on some count. We are also entitled. I am not saying here counterclaim and all that, my lord, we have not made counterclaim, that's true. But separate suit is pending. We are entitled to, we say that 11,30,000 what we are entitled to, plus 6,75,000 for damage. So after whatever settlement they made, both the parties can settle and finish the matter. In plaint also we have made that statement that we approach them for negotiation.
That is something else. But this
Billing and destination, you will also will kindly see in para 134. No bill was raised at all.
No bill was
No,
raised.
nothing is there on the card. No bill was raised at all. The dispute started because even if the supplied malord has seen the challan, my lord, I am not saying at this stage, my lord, but the cross examination, this question was put to the my lord DW1 that these persons whose signatures are there are your persons. He says that no, these are not our persons. I'll refer to my turn will come in, or I'll
No,
refer
but
to those.
that may not be believable. That may not be believable.
Huh?
That may not be believable.
Well, they have to prove also. No, these
No,
are
that's
my
okay.
person has signed it.
No, legal proof
Because
is
your
some-
lordship will kindly see one aspect of the matter.
No, legal proof is something else.
No, true, my
But,
lord. Your lordship,
I-
by probability, normally, my lord, your lordship will think that it is not believable. But
No,
your lord,
because you see, I lived my entire life in a place where even the this porters, the Therawala, they will sign it and the owners accept it. That amount.
no, that my lord, in business terms that goes. My lord, but your lordship will kindly see one aspect of the matter, that 30 kilometer and 12 kilometer prior to the site they have already. Yeah.
That's
Then
okay.
who
That's okay.
received the goods?
But I've seen what do you call this laborer and this what do you call Thelawalas, rickshawalas making transactions, transporting goods, huge amount of money goes through them. And I've never come against one incident near near the place where I stay, where any of these laborers, rickshawala or Thelawalas, were accused of stealing.
Accused of?
Stealing or diversion of goods.
And they are not very, my lord, yeah, honest.
Absolutely honest.
Honest. I know that, my lord. The steel, my lord, in Fancy Bazaar, if your lordship goes.
So that's what I'm saying.
My lord, I have seen myself.
But
I've
they
seen
will
myself.
they will give keys to the godown keys to this Thelawalas. They will go there, pick up goods, come back, and nobody has ever complained that it's because of these laborers something is lost on this place.
Still, my lord, when I go to market, my lord, sometime I take the, my lord, because their goods are heavy and all that, I say that gadi mein de ke aa jao. So they go and give it, and whatever they took it from, they have delivered there. They will not take a single here and there.
No.
Not. They're very honest.
It was their site, my lord, they have received. Actually, in some of the trans, my lord, series there is not that, my lord. They say that was distant place from the AC, my lord. That's under spectrometer. But at the site, my lord. At the site, it was made.
No, but then, but then, Mr. Sayola,
yes,
you stand to lose everything. You see, without a bill, a challan or a ledger is not an acceptable proof of amount due.
So ledger
is a secondary entry.
Secondary evidence. Section 34 or 33, I think.
34 is books of accounts.
Books of account.
This can't be a primary entry to give you anything. Liability cannot be settled on the basis of this.
In fact, my lord, I can say, my lord, there is no cause of action arose for, my lord, claiming that amount.
Appears to be so. That's why I stopped you from making a full-length argument, because 2 or 3 things I thought that I would ask first and then start with the matter. My lord. Because in the absence of the primary proof of dues, that is the bill, this would be otherwise also be dismissed. This appeal will have to be dismissed. And that's the only issue of this, what you call, that power of attorney, that we can always make a comment and then say that this trial court should take into consideration that big issues may not be made.
my lord will fix the matter.
Hmm?
This matter when your lordship will take.
If that answer, Savala is able to give, that we close the matter with the.
But there is no bill, my lord. My lord, I have seen it. My lord. That's what I have pointed out. There is no bill.
No, no, losses will fix it, madam.
When?
Then they will.
Friday?
Huh?
Friday, next.
On Friday. Friday, I have some difficulty.
Hmm?
I have some difficulty. If your lordship can take on.
Because this Tuesdays and Thursdays, we have a lot of fixed matters.
Thursday, though, your lordship has fixed, I think.
Division bench matters also.
Yes, that's reference. One of the references where I am appearing as an amicus curiae. I know that.
But two are fixed on that day.
Yeah, I know about one, my lord, because that Nia's case that your lordship is hearing. And now the question arises for consideration whether there was a sanction under section 16 so far Ajay Vasumodar is concerned. Probably that is not there.
No, because just.
No, just I am.
No, that was the first argument which should have been made was in the middle of the argument.
But I am reading the judgment, my lord, though I do not have to, my lord, enter at this stage, as my lord has pointed out on that day, that my role will, if at all comes, my lord, whether death penalty will be given or not, if that is decided at that point.
That's what I thought.
No, that is true, my lord. That is, in fact, my lord, I told them, they were insisting that no, you start arguing. No, why I asked, why should I start arguing, or why the prosecution should start? If you are filing an appeal against conviction, you first argue. If the conviction goes, everything goes.
Everything goes.
Why should we labor on the whether death penalty should be given or not?
Yeah, correct.
I told them actually earlier, but they were insisting on that the prosecution should start. You are amicus curiae, you should start. Well, why should I?
Because we consulted each
Court,
other.
my role will be, my lord, if your lordship feels that no, my assistance is required, then I'll definitely lend my
Only
hand.
then.
Only then, will. Otherwise also not that.
Because it may so happen that in the criminal appeal also, while hearing, we may take a decision, it's not a case of death.
Yes.
Without even hearing
Yes,
US
yes.
amicus curiae,
Yeah.
we can still say that it was not
Still
a
then.
intention to kill and
Still
then
then.
therefore.
Amicus curiae is kept, my lord, because in these cases, that if the court needs any my lord assistance, that can be taken. सही तरीके तारीख की हो वो
But then the only day available would be fourth.
Fourth, can it be?
Either fourth or sixth, because
Fourth,
then-
no, let it be fourth.
Fourth.
Fourth will be not. I have not any difficulty. Fourth.
The submissions of Mr. G. N. Savada, Senior Counsel, assisted by Ms.
TJ Sayola.
C. G. Savada, okay. And Mr. K. Agarwal, Senior Counsel, assisted by Mr. M. Das, Counsel for the respondent, remains inconclusive. List again on 4/10/2023.
We are or actually, a part had or not required.
It is inconclusive. I said.
Itself part.
It itself is indication.
Itself part.
Please, your lordship.
Yes.
Lordship, item number 12. This matter has been listed wrongly for hearing. Kindly, it may be listed.
Oh, 12, I was required to look at the record. Yes, just a moment. Item 12. I'll see the record. It's a review matter, so therefore.
Your lordship, kindly, the matter may be listed for orders on 4th.
Just a moment. Let me go to the records. No, this is not wrongly listed. The matter is not wrongly listed.
Yeah, there is an order passed by learned Justice P.J. Saikia,
Yes.
but it have to be listed for orders, Your Lordship.
No. Once the court has said it is for hearing, we take it for hearing. It's not a hard and fast rule that the review petition has to be disposed of in the order stage only. Correct. So once there is a judicial order, you don't disturb that judicial order. Once an honorable judge says that we hear the matter, we hear it. Correct.
Okay, Lordship, then kindly fix a date.
Possibly time matter could not be taken up today, this term. This one says for hearing as for order hearing 4/8/2023.
3.
What has happened to the settlement? You are aware of it? No. This is